more fallout from that nurse case. I mean, now all the finger pointing has started. And you may have seen that one of the administrators who was criticised by one of the doctor witnesses during the trial, because he said, we took these, we reported our suspicions, we said you need to take her off the ward, and they refused to do so. And she's saying, no, that's not true. You never, this was never relayed to me. They never explained why they thought she should be removed. And what she's actually said is, she said, I'm consulting lawyers about my legal options here, with the implication she may, want to sue for defamation. So can she? Well, the simple answer is no, she can't. As we've discussed in other videos, when you give evidence in any sort of formal proceeding, whether that's criminal or civil, that evidence attracts what we call absolute privilege. And that applies to the oral evidence you give, anything you put in a witness statement, or even just speaking to lawyers beforehand. Okay? Everything there attracts absolute privilege. And what does absolute privilege mean? That means that you cannot be sued in the civil courts under any cause of action, defamation, fraud, harassment, anything like that. You have absolute blanket immunity. Even if it transpired you were indeed lying through your teeth. I mean, I'm not suggesting anybody here was. But even if it was proven that it was false, and you'd done it completely maliciously just to badmouth somebody, it's tough. The person has personally no remedy whatsoever. What's the rationale for that? Well, the rationale is, when we get people to court, we want them to be able to give evidence sort of, frankly and truthfully. And if people thought, well, I actually might get sued for, getting involved in this or giving evidence, there's collateral litigation, that would put people off, telling the truth as far as they believe it. So the idea is, on a strict utilitarian basis, on the social balance sheet, it's better that some people just have, malicious things said about them than genuine witnesses are discouraged. And like I say, that covers everything. If even if somebody rings the police and lies about you, puts in a false accusation about you, you can't even sue on the back of the phone call. Now, that's not to say that action can't be taken. People can still be subject to contempt proceedings and prosecutions for things like perjury or attempt to pervert the course of justice. But generally speaking, with the criminal offences, it's the state that has to bring those. Okay, I mean, normally you can bring private prosecutions, but the DPP, sometimes you need the consent, or the DPP can take over a case and just dismiss it. So yeah, I mean, if the state says yes, you have lied through your teeth, then they can go after you for perjury. But the actual person, who was, maligned, they have no say in this. So there you go. So yes, so unfortunately, whatever her grievances are, she has no legal recourse whatsoever. So anyway, hope you found that useful or interesting. If you did, please consider clicking the like button, subscribing and sharing.